All right, everyone. It's 1 o'clock, and so we can get this thing started. Thank you all very much for attending today. Before I go too far, I'm going to let you all know this is going to be recorded and emailed. So if you signed up for this presentation, then this, whatever happens today, whatever happens to come out of my mouth, you can listen to again and yeah, do presentations to if other people in your office and things like that. It'll be available on the NC Realtors YouTube page, so go ahead and find it there, or you can wait for the email to come out. If you miss the email, that's where it will be. So. My name is John Waite, General Counsel at NC Realtors, and I'm joined today by Amy Hedgecock and Pam Green. And we are going to be going through the forms changes for the cycle for the property management division. This group worked really hard and they did really well with the forms changes this year. So I'm going to share my screen and let's see. There we go. And I'm going to start with just showing you guys how to navigate to where we are today. Uh, can everybody hear me okay? I presume it seems like I'm talking to no one, but if you can't hear me for some reason, or if things are not working, then just be sure to let me know. In any event, here on ncrealtors.org, if you hover over the legal and ethics, then you can go to legal Q&As, okay? And if you want to see past years summaries, then you can click on this button here, and then you can see summary forms changes down here. But these particular changes that we're going to cover today are actually right here. These are in chronological order. You can sort them however you want, but they are by default sorted by the date that they came out. And so right here, you can see property management forms. You click on that, and it will take you to this Q&A. And these links here will take you to the strikeout versions of the forms that I'm about to go through in about 2 seconds. So as you can see, we're going to be going through the property management agreement. There's a small change there. Form 410, the residential rental contract, where there's some changes in there. We got two new forms that we're going to cover. There's a small claims summary judgment flow chart, and finally some changes to the notice and demand for possession. So let's start with the property management agreement. And in here, you can see not any big changes in this form, at least at the beginning. Down here, you have a change to this section is for authority and responsibilities of agent. Okay, so this is what property managers, what you're agreeing to with your client. And what it says here is that the owner understands that firm has no duty to pursue claims or appeals in district court, and that firm in its sole discretion may limit claims in summary judgment cases to past due rent and against the tenant. A few notes about this. I know you guys often will throw in things in a summary judgment case other than past due rent. But technically speaking, the statute that gives you the authority to go to small claims court for your landlord gives you the authority to seek past due rent as part of an eviction case. And that's it. Like that's the extent of the authority in the statute. So you can argue sometimes, or you could make the argument generally, I guess, that if you're bringing claims for other things, like for damage to the property and things like that, as part of an eviction case, then technically that's not allowed. I'm not sure that that is black or white, but it is something to be aware of because in a lot of cases, based on how a tenant, actually exits the property, you may have damages that aren't known yet when you bring an eviction case. So when you're bringing that as an initial matter, you don't know what the damages to the property are. And I know a lot of you know this already because you guys practice this every single day. But all that is to say is that if you feel like it's appropriate to bring those sorts of things and just to be efficient, then I think it's something you may do with the landlord's permission. Just understand that it's not part of the statute. If it's not part of the statute, then it's always been my worry that if something were to go wrong and you wanted to trigger an E&O claim, if it was outside the scope of the statute, then the E&O carrier may, deny coverage on something like that. So I guess I'll put it this way, I'll just be very careful. I've never heard of an agent being disciplined for doing something other than past due rent in a small claims case. But definitely if you've got a landlord who's asking you for something like, hey, I really want you to, we've already done the eviction of the tenant, right? You've done that, it's undone, it's over, tenant's out. And then they're asking you to bring another case for more rent or for more damages to the property, things like that, late fees, cleaning fees, or whatever. Let's say they want you to bring claims like that. This was added so that you would be able to have something, black and white in your property management agreement to make it clear. No, sorry, Mr. Landlord, we really like you and everything, but this is not something that we can do for you. And this language is meant to give you the authority to draw that line, but also in the instance where you've brought a claim for a little bit more than rent, like for a late fee or something like that, that somehow that wouldn't exclude E&O coverage for you, or create some kind of issue for your E&O because of, if the language was worded stronger, which was debated at one point in the property management forms committee, then it could be argued that you were acting outside the scope of your property management agreement, and then that would also be an E&O problem all in its own. So all that is to say is this language is very intentional. I think it's a good addition to the property management agreement. It's a small one. Amy or Pam, I don't know if either one of you had, thoughts on this in addition to that, but if you do, you can chime in, and if not, I'll move on to the residential rental contract.
Pam, do you have something to say first?
No, floor is
Oh,
yours, Amy.
I was just going to say, just a quick aside. We've all been there where our clients have said, "Hey, I know you evicted them, but I really want to go after them for money owed." Um, it's really nice to have this language in here now because I've always said that's beyond my scope, and you're more than welcome to chase that down yourself. But it is a nice touch that we have added this in for some clearer language. Thank you, John.
All right. Moving on to Form 410, the residential rental contract. I know a lot of you are using security deposit alternatives, so now there's a line that's been added for that. When the forms first came out in zip forms, there was an issue with this checkbox. And just so you guys know, Lee and I proof the forms pretty thoroughly before they go out to the vendors. But there are some vendors that when they input it into their system, sometimes errors happen. And that was something where this checkbox right here actually covered over the A right here. So if you see that, then that's where that came from. I believe it is already fixed now, but if you notice other things like that, feel free to bring them up with us. We'll go ahead and work with zip forms and make sure that they get corrected. In the residential rental contract, this is a technical change here, just to make it clear that this particular obligation to make repairs to the premises is subject to paragraphs 11 and 18. Paragraphs 11 and 18 down here, you can see payment for repair of damages, so it makes accommodation for that, but also, and probably even more importantly, it's what the landlord's default and remedies and damages. So things in this nature. So even though the landlord has the duty to make repairs to the premises to keep it fit and habitable, there's a lot more that goes along with that in the lease itself. So just to make sure that this particular obligation is subject to those paragraphs, meaning that it has to accommodate for those other provisions. Here you've got a deletion, but it's not because this deletion now the tenant doesn't have to pay for any fees. Instead, more generally, now I'm going to skip down a couple of, oh yeah, here it is. It's in now paragraph 17F, where it just says blanketly, should the landlord or agent incur any fees due to the tenant's failure to comply with the contract, including trip or municipal fees, then the tenant has to be liable. So instead of having it, be something that's more narrow, now it's actually more broad. I think there was one example in the committee about, the tenant making the garbage collector come out more than once. But I think this would also apply anytime you have a vendor go out to the property and then the tenant refuses access or something like that, and you incur another fee. Did you guys have anything to add on that one?
I do. That's one of the things that, most of the time when you send a vendor out, the work order comes in, you send the vendor out, it's scheduled with the vendor goes out, knocks on the door, nobody answers. Who's going to pay for the vendor's time? So, and typically that would go towards the tenant, but this actually puts things like that in writing. So we now have something to refer back to when you get the tenant that comes back or the client that comes back and says, okay, show me in my agreement where it says this. So that line item was absolutely phenomenal. So we appreciate that section to be added to the residential rental contract.
All right. Let's see. Yep. Okay. There's that one. So moving back to paragraph 16. This one, I don't know how this is going to go down. Honestly, this is one of those things where let's put it out there and see what happens because you're already doing it anyway, and not you, your sellers slash landlords, right? So I get the question on the hotline pretty often on the NC Realtors legal hotline where the landlord has just had their fill of tenants. They hate being a landlord. It's just not for them. And so the tenant gets out and they want to keep the deposit, but you can't just keep the deposit because you have to follow the statute, right? But the landlord often doesn't understand this, and even if you tell them, they just don't want to listen, whatever. They're having a teenager moment, if you will. And so the question always to me on the hotline is, can the landlord sell the property and still be considered to be mitigating their damages? And in my view, if they're under the old language, it was kind of a murky question because it was a little bit more definitive that the landlord needed to re-rent the premises. And so there's a question about whether that was required, mandatory, or whether there was actually an option there. I don't think it was necessarily clear, but to me, if you wanted my personal opinion, I do think, depending on the market and the circumstances, that should be an option to the landlord where, no, we're just going to sell the property. It'll actually be faster. In some cases, it may actually be faster. So that now you have this language added in to give that explicit discretion to the landlord. So uh, I don't know how a court would treat this. I just wonder if, they might think that's a bridge too far. I don't know. But I do think that it's something that is in the realm of something that can be negotiable as part of the lease. So now you have it in here. If there's any issues with that, if you run into any issues with that, for example, in my view, the most likely challenge would come from, say, you know, somebody who's in legal aid or something like that, bringing it up in probably one of the bigger markets. If you hear something like that, feel free to, give me a call on the legal hotline and I'll make a note of it. I kind of want to keep track on this one because if, there's challenges to this and it's not working as intended, then it might be something where we want to make some adjustments to it. Any thoughts on that? All right. Moving on. Also in paragraph 17, we already covered the other fees and costs there in yellow. There's now a provision for, death of the tenant. It's just becoming more and more common. And I don't know why that is, but it just seems to be more and more common. I've been getting more and more questions on the hotline. So this cycle, we went ahead and worked on a draft. So now that if the tenant dies while in the possession of the premises, tenant directs that their personal property be released to blank. Or, this is this is a list coming up here. So it's not just the blank. Fill in the blank, yes. But also the emergency contact, personal representative of the estate, or any executor named in the tenant's last will and testament. So any of those people. So, and then there's also a hold harmless there if that property gets left out. Right now, if you got an old lease, usually what I tell people is that, if somebody's got a key to get in, it's not, I would just say be careful in making sure that person has some kind of authority to get in there. It's not like you're necessarily explicitly under the lease in charge of policing the keys of a tenant who's passed away. But there's also this thing in the law called involuntary bailment. And what that means, it's not bail bonds, okay? Those of you who are criminals probably would have some idea of what that is. No, bailment is not that. Bailment is sort of like you're put in charge of just holding something for someone, okay? And it's not yours. It's not like you have possession of it and you get to actually take ownership. It's more like you're just looking after, looking after it for a little while or something like that. For example, in the movie Dumb and Dumber, when the little old lady steals the big foam hat and all the beer from Jim Carrey, she was in a bailment situation. And yeah, in that case, it was a voluntary bailment, right? Because he asked her, "Hey, little old lady, will you watch this stuff while I go get some cash?" And she smiles and says, "Yes." So that establishes a voluntary bailment situation. She is now going to watch his stuff while he goes and gets some cash so he can get his wallet out of the magazine machine that he locked it in, right? So in the movie, that she wanders away and steals all his stuff. That is a violation of that bailment relationship that was established, and she could actually be held liable for that, not just theft. You could actually turn that into you violated your voluntary bailment obligations. For you guys, you end up more often in what would be considered in the law an involuntary bailment situation, which you have all this property from the tenant, maybe, and you don't really want to look after it, but you don't really have a choice either, right? So that's what can happen in these cases. And so that's why, if somebody's a key and they're getting in and out of a house after a tenant has passed away, you probably want to do some digging on it. I wouldn't want you to be, put it in a situation where you could potentially have liability there. I'm not saying you're in charge of the tenant's stuff. It's not like you're the police of it, but you also want to make sure that it's not getting looted, if that makes sense. Take reasonable steps to try and make sure that the tenant stuff goes to the appropriate person, which would be whoever the beneficiary is under the estate and things like that. In any event, now this paragraph though clears that up even further, so that you can do that and keep a track on it. So if somebody's not one of these things and they got a key getting in there, then I think you would be within your rights to just say no, you can't do that if you wanted to. It could also be something where, depending on the circumstances, maybe they're helping you out by getting personal property out that otherwise is just junk. I don't know. It's something that if you have a situation that comes up in this arena, and you want to call the legal hotline and talk through it, that's fine. These are things that we talk through all the time, kind of give you guys ideas about that. But that's what this paragraph is meant to address to try and bring some clarity to that. Do you guys have any input on that?
Of course, I have input on this one. We've dealt with a lot of, unfortunately, dead tenants. So I actually really like this. It's probably one of my favorite additions that we made this year. Not that it's going to solve all your problems if you have someone who has passed, but it is a place to start. It is giving you names and numbers of people that you can contact, which is good when you're stuck with someone's belongings and you don't know where to turn. This is just a great little addition. And also, frankly, we've used it in the last lease we signed, just to make sure that somebody knows, I'm sorry, memento mori, you might die. You will die eventually, and you might die in this house. So please give us an idea and at least some concern that you have about who's going to take your items. And a lot of lower income tenants I have found along the way do not have a lot of people clamoring to come get their items. They're also the ones that are least likely to have a will set up. But this is it's a good start. And I hope that it will help alleviate some issues across the state when people run into these kind of dire situations.
Thank you. All right. Moving on, we got some subheadings here, nothing that big of a deal, but another paragraph that I think is a good addition is, all right, if the property has suffered significant damage and it's not fit and habitable anymore, then what is the remedy? And I've gotten, even since July 1st, on the hotline, I've got this question 4 times again. And the great thing is now I can tell people, well, going forward on the new lease, this question is answered with definitely some definitiveness. The landlord does not have to pay for a hotel. Okay, that is almost the most common way that question is phrased to me when I get it from a property manager. The answer is no. The landlord does not have to pay for a hotel. Yes, the landlord should give credit, for rent for the time the property is not fit and habitable. But otherwise, no, the landlord does not have to pay for a hotel. The landlord has to take reasonable steps to try and, repair the property, sure. But that doesn't mean that, they can, and because if the landlord delays too much in trying to get the repair done, then I think the tenant could make some other claims about how, the purpose of the lease is being frustrated and things like that. They could try to get out of the lease entirely if the landlord takes too long to make a repair. But some repairs, some of these damage repairs where the house is not fit and habitable are significant and take a long time. So this makes clear, that the landlord can give a credit, but no, the landlord does not have to do that. Moreover, it also says the landlord may request that the tenant vacate, which I don't even know how many times I've got the phone call where a tenant refused to vacate, even though the property's not fit and habitable. So the tenant is there yelling about how the property's not fit and habitable, but then also won't leave so that you can bring the property to a fit and habitable state. So in any event, this paragraph is meant to address those situations. And so hopefully, that's helpful to you guys. I would argue also on an old lease, this is still the remedy. Okay. It's the same answer that I give on the old lease as well. It's just now you have a paragraph to point to for the tenant. Yeah, go ahead.
I don't mean to go backwards here, but I noticed that we do have a couple of questions in the comments section or in the Q&A.
Yeah.
So one of them is, I guess, back to the death question, raises the question of how we ensure someone knows who their property manager is so that we're notified even in their death. And I guess that's not really a question. That was more of a statement. But this one is, but does it give you the right to empty the house? Do you have to put the dead tenant's stuff in storage?
Well, there's a couple different things to do on this, and actually, this was a discussion we were having right before we got on this webinar. And where did that article go? Well, that's irritating. Did I get rid of it? In any event, if someone dies in the property and the property is unoccupied, okay, then here it is. Yeah, I found it. Haha, it was on my other computer. Yeah, I think it really depends on whether the property is occupied or not. If the property is unoccupied, there's an affidavit you can do, although I think probably some of you at the past, maybe even at my recommendation, have done evictions of dead tenants to get jurisdiction over their stuff, because that's how you would get a writ. But in any event, there is an affidavit you can fill out from AOC that has to do with the tenant stuff. And there's a 90-day period in there that's part of that affidavit. So definitely you can follow that. If the property is occupied, though, I think the safest route would still be an eviction. If the property is truly unoccupied, though, probably the affidavit would be the safer way to go. It's just it just depends on the circumstances. So, yeah, I'm not sure if that answers the question squarely or not, but that kind of gives sort of a broad view of the options.
We had a couple more, John. What happens to the security deposit of a deceased tenant? And we have a statement that says, I find there is not enough space at times for bank and name, address anyway to single that out. So that's something on where the security deposit is held. And is the dead tenant's estate liable for rent?
Yeah, I mean, the lease does fall. It's a property interest that falls to the estate. So technically, that means the estate has both the benefits of the lease, which would be possession, and also the obligation to pay rent. Generally speaking, that's always been my understanding. As far as how the law works in that situation. So that means when you do the accounting of the deposit, and I haven't used the affidavit before, as far as dealing with a dead tenant and their stuff. I don't know if it addresses the security deposit or not, but the statute says that the accounting for the deposit has to be done, within 30 or 60 days of when the tenancy ends. Well, when does a tenancy end? Does it end like, when the tenant's not in possession anymore? Maybe. Like I said, if there's somebody still in there, like another occupant or even another tenant, then, is the tenancy done? Probably not. So it really just depends. But in any event, eventually, somehow, some way, there's no, to my knowledge, unless there's something in the affidavit, the AOC affidavit, unless there's something in those statutes that I'm not aware of, then the accounting for the deposit would be the same. as usual. All right, we'll keep on moving. Let's see. Actually, that might be it for the residential rental contract. It is. All right, so that's it for that. Let's move on to a new form. This is the small claims summary ejectment flowchart, and it's really just meant to be exactly what it is. I brought up with the committee that I was getting plenty of phone calls from agents and agents who are managing their own property, as well as agents just wanting some simple, a simple guide to summary ejectment. So the forms committee came up with this chart. I think it's pretty good. It also has a second page that has some important information, including an explanation of terminating possession versus terminating the lease, which I think is helpful because you guys probably terminate possession all the time, but don't really think about the fact that terminating the lease is also an option. And this makes clear that terminating possession should be the default, like that should be what you use probably 99% of the time. But there may be some circumstances, especially in a commercial situation, where you may want to terminate the lease instead, or at least have the landlord give some information about that. So, yeah, thoughts on that?
This was my favorite addition. I, having being in property management, it's kind of second knowledge now. But for those who are helping their clients and doing what is best and trying to keep the peace, this is almost one of the best things that I think the Forms Committee has come out with. The process itself does not change. That is the actual process. While the outcomes may change, this is the actual process. So this was one of my favorite additions because it does go through the steps with the logic on what to do next. So it's more now of a guideline for agents who are handling these on behalf of their clients. So I was really impressed with the Forms Committee for coming up with this.
All right.
Same. And John, looks like you got a few more questions here. One of these, well, a lot of people on death. What about the death of an owner?
All right. All right, hold on. Da, da, da. I'm just going through these real quick.
Someone did ask about the small claims summary ejectment flow chart. That is Form 418.
Yeah, so I mean, if the owner dies, if you have an owner that dies, yeah, their estate still owns the property. And besides that, the tenant also has an obligation to continue to pay rent, whether it's to the owner or to, the owner's, next of, whoever inherited the property also inherits the obligation of the lease. So when an owner dies, the weird thing is you wouldn't actually have a property management agreement to actually manage the property for the new heir, unless you actually sign one with them. So it's a difficult process. It might be something where if you can't work it out with the heir to get a new property management agreement, then you might not be able to manage the property anymore because you don't have a management agreement with the owner of the property, if that makes sense. All right. I'm going to come back to these questions at the end, so I have a chance to read them. I'm going to keep moving for the moment, but we will come back to those. Let's go to changes to Form 427. This is notice and demand from possession. And you can see here, there's been some changes to accommodate criminal activity in the middle paragraph. And that's really what that is, probably the biggest change in this paragraph. So that now, you can do your intermediate breach if you fail to pay rent or if you commit crime on the premises. And then finally, if you breached another condition and then failed to cure. But as to those first two, there's no cure period. So Form 4027, that's already in the lease itself now. So it's really just making the notice and demand for possession match what is already in the lease. And then finally, what we got here is a brand new form, notice of month-to-month tenancy. Do you guys want to talk about this one?
It seems sort of self-explanatory. I don't know. It's a form that you can use as a month to month, so that you don't have to keep using that same lease from 2019. I mean, it would still apply. You're just moving forward with the same terms, correct?
Yeah. It's really the purpose of this. The committee wanted a standard form to send to basically remind the tenant, hey, we've gone to month, and the lease continues to be in effect, and here's your new rent adjustment. But otherwise, this is what we're doing now, unless you sign a new lease. And so that's really what it's about. And as it says at the top, make sure you follow that. It's really only for 2023 or later, because there were some big changes in 2023 regarding month to month and being able to change the rent. On leases prior to that, you can't just unilaterally change the rent. That was not added to the rental contract until 2023. So that's why that is up there. All right, let me go ahead and look at the Q&As here. So Brian says, do we need to send this to the tenants as the initial term of their lease is about to end for all leases? No. Need, I would not say need. That is not the way I would phrase it. It's really just about, if you want to, you definitely can. I think making sure the tenant's on the best page possible, that would be as good. If you have a renewal form that you use already, this would not be, instead of a renewal form, this is not a renewal. This is just a notice to the tenant that you're going month to month. The renewal form is a different form, and that's what you would use to actually extend the lease. The renewal form in the forms library is, let's see, 425, 425-T. So that's the form number if you're going to renew the lease and extend it. So no, this new form is not for that. This new form is really just to, let the tenant know, here's what, we're going month to month. Here's what's going to happen. Here's your new rent. No, it is not an addendum to the lease. It is an independent notice that you can send. The form number for the new form is form 428. So 428 is the form number for the notice of month-to-month tenancy. What happens if the tenant lives alone and does not have an estate or will? Does the security deposit stay in trust account held by the property manager? I think we covered that one already. And if we didn't, feel free to let me know. Is the dead tenant's estate liable for the rent? Yes, I answered that one already. Yeah. So yeah, as far as storing dead tenants' items, yes, that's likely going to be required for 90 days. Can you file an eviction if death and non-payment? Death and non-payment. Probably going to have to go the affidavit route unless you have another occupant in the property. Does the security deposit statement need to be done within 36 days of the tenancy ends or when the tenant moves out? I think I covered that one already, but the answer is the statute says that when the tenancy is over, that's when you do it. As far for a dead tenant, it's going to be 90 days if you use the affidavit. If you're doing an eviction to get a tenant out, then including, like extra occupants for a deceased tenant, then that's something that would be a little bit different, and you would do an eviction for that. It would probably change the personal property aspect of that as well. Yes, if you're going through an eviction for the first time, again, I would encourage you to look at the flow chart. The flow chart is Form 418, but if you're doing your first one and you want to talk through it, that's what the legal hotline is for. And Savannah or somebody, maybe you can drop that information for the legal hotline in the chat. Yeah, in the chart it says 10-day notice is not required. The 10-day notice is something that you can use for an eviction when the lease itself does not cover when the landlord can demand possession and seek possession of the property. Because our lease covers that, that's why a 10-day notice is not required, and that's why the case is actually cited there. That's what that case, that court case talks about. Can you use this change to rent even if they've been on a month-to-month tenancy for a while? Yeah, it depends what lease you're on, but the lease, the newer versions of the residential rental contract say that in a given month you can change the rent for the next month, for the next rental period. So just make sure the lease allows you to do it is the important thing. Yeah, so this is the notice of month-to-month tenancy is not, it's not anything other than a notice. It is not, it doesn't amend the contract, it doesn't renew the contract, it doesn't do anything. So that's something, it's really just talking about the landlord has not received anything to indicate that the tenant is renewing the lease. Usually this is going to be something that you may use if you're sending out a renewal form and then it's not signed by the tenant. That as far as whether you would use the notice of month-to-month tenancy, you don't have to use the notice of month-to-month tenancy. This is not a mandatory form. The lease itself, indicates that the lease is that the tenancy is going to move to a month-to-month once the initial term is over. So you can use this, or if you actually do want to extend the lease, then you would use the extension form. And that's again, that form is 425. When a tenant dies, you guys can go in the apartment during reasonable hours. So here in the lease, the important paragraph on this is the right of access, right of entry. And it's right here, paragraph 10. And I've had several cases recently where I've been helping property managers where the tenant thinks that they can deny access. No, you guys can go in during reasonable hours. And then you've got 1 through 4 there in that paragraph but that's pretty broad, So yeah, you don't have to give advanced 24-hour notice, nothing. So that includes a dead tenant. If you want to get in there, you can get in there. Is there a certain amount rent can be increased? No. There's no rules on that as far as increasing rent for a month to month. Okay. That is all we have as far as form changes for you guys. I believe we've answered all the questions. If we did not get to a question, or if you think of one later, don't worry. My guess is, has someone put the legal hotline in the chat? Yeah. So Savannah's put the legal hotline information in the chat. Feel free to call or email. We are happy to help you as a free member service. And I can tell you, property managers take advantage of it pretty often. So feel free to use that if you have questions. Don't feel like you have to get them done today necessarily. We're happy to help you out. Thanks, Pam and Amy, very much for joining today and giving your input. Appreciate it. All right, I'm going to stop sharing my screen. Chelsea and Savannah, do you have anything else for us? All right, I guess not. Well, in that sense, from me and everybody else here at NC Realtors, the Property Management Division, thank you all very much. You all have a great rest of your day.